There are some things where I think if people trusted their gut early on, it might save them a lot of heartache. So I'm thinking of if you're working with someone and they seem shady, or they seem like they're on a different page than you, or they're making decisions without consulting you or anything like that, and it gives you sort of a gut feel, but you're able to explain it away. I think that there is huge value in just listening to your gut and thinking, okay, this might be indicative of what our relationship is going to look like moving forward. Do I want to do that? Is the benefit so high that that risk is okay? And at least acknowledging that you are making that trade off.
Welcome to Sterling Insights, Stand Out and Supercharge Your Assets, the go-to podcast for financial advisors aiming to grow their assets under management, stand out in a crowded market, and retain assets nearly forever. Are you advising high net worth clients who own appreciated capital assets? Do you want to help them sell without losing a quarter, a third, or even more of their hard-earned profits to capital gains taxes? Then this podcast is tailored for you. Each episode brings you the latest strategies and expert advice from leading financial advisors, seasoned attorneys, and experienced CPAs. Learn how to maximize your clients' wealth, minimize their taxes, and supercharge your advisory practice with actionable insights. Join us on Sterling Insights, Stand Out and Supercharge Your Assets, where you'll gain the knowledge and tools to set yourself apart and achieve unparalleled success in wealth management. Subscribe now and empower your practice for a brighter, more prosperous future.
Welcome back to Sterling Insights. I'm Seth Krussman, and today we're diving into a part of business many owners don't like to think about, but should. High-stakes litigation, risk management, and what happens when business disputes go to trial. Whether you're a startup, a scaling business, or a long-established company, understanding how to protect yourself before conflict happens can save time, money, and relationships. Our guest today is Josi Kovacs, a complex commercial litigator at Portland's Markowitz Herbold PC, one of the premier litigation boutiques in the Pacific Northwest. Josi represents businesses, individuals, and institutions in high-stake disputes, from contract and partnership litigation to real estate conflicts, professional malpractice, and commercial liability cases. With trial experience in state and federal courts and a reputation for cutting through legal complexity to deliver clarity for clients, she knows what it takes to navigate disputed waters in tough cases. In today's conversation, we'll peel back the curtain on what complex commercial litigation really means, common pitfalls business owners face, how to decide whether to fight or settle, and most importantly, what you can do now to avoid being reactive. Whether you're a founder, business owner, investor, or simply want to understand how legal risks affect long-term growth, this episode's for you. Thank you for being here.
Thanks for inviting me.
So can you tell us or walk us through your path to becoming a commercial litigator and what attracted you to complex business litigation rather than another practice area?
Sure. I started out as a pretty full service defense counsel. I worked in a lot of construction cases, personal injury, insurance defense. And that was a great experience because I got to work on smaller scale commercial disputes and really run those cases early on. I got some trial experience as well. It was a great stepping stone in understanding how to manage complex client relationships and client emotions. But I really wanted a more complex challenge. I really enjoy, my favorite part of my job is getting to learn something new every case, every dispute that I have. Once you do a couple cases that are really similar, there is something I think that's lost. And so I really enjoy, since I've been at Markowitz, being able to deal with really strange problems and find creative solutions for them. and learning something new, a new business area, a new area of law, how to apply that new area of law, whatever it is, there's always something new and different. And I think the benefit of that is being able to kind of approach it from a creative standpoint.
You joined Markowitz Herbold a few years ago. What stood out to you about the firm that made you decide to join? And how have the last couple of years been for you so far?
It's been incredible. I always say that it's pretty excellent to be able to work with a bunch of litigation nerds. It's a bunch of people who love thinking through problems and dealing with these strange situations. When I came to Markowitz, I was looking for that place where I could make the transition, work on these really complex issues, come across new issues, and really be someone's trusted advisor through that process. Litigation is such a stressful experience, even for a seasoned business person. It's just a really stressful, intimidating experience in a lot of cases. So when I came to Markowitz, I remember meeting some of the attorneys, especially the women attorneys, for the first time and thinking, this is where I need to be to get that trial experience and to be able to help build up a firm with what I have to offer too. Markowitz Herbold has a great history of really founded as a place that women could be trial lawyers in a time period where that just wasn't the case. It was the 80s in Portland. And women could be lawyers, but they were researchers. They were behind the scenes. They weren't trial lawyers. They couldn't be. So we have such a great tapestry of all the different ways, not all of them, but lots of different ways that people can be lawyers. This fantastic element of just like humanity almost. Like it feels like every time you talk to one of our lawyers, they're you know who they are. They're authentically themselves, and that is what makes them an excellent lawyer. They're able to harness that and find how to use that for their work. I think that's what sets it apart. And that's why I really wanted to be a part of this firm.
Wow, you really set it apart there. I want to go tomorrow or today after we wrap up. This is awesome. For listeners who may not be familiar with what kinds of disputes typically rise to complex commercial litigation, what differentiates them from simpler civil disputes?
There's a bunch of different things that really go into it, but usually it's the size of the dispute, the amount of money in dispute, lots of parties involved. Sometimes it's that there is a lot of backstory. Maybe there's already a decades-long dispute that feeds into the present dispute. And oftentimes it'll also involve just huge amounts of discovery, huge amounts of documents that have to be dealt with and managed, reviewed, evaluated, analyzed.
You've worked on cases ranging from partnership dissolution to professional malpractice, contract disputes, real estate issues, product liability. Which kinds of cases are particularly challenging and why?
I end up doing a lot of partnership or shareholder disputes, and I think a lot of those cases can be difficult because there's so many different ways that they can move forward and so many different issues that can come up. So I'm thinking particularly of closely held corporations or a family business. There's usually a lot of emotion involved and a lot of backstory, and sometimes those cases are particularly susceptible to not having documentation or it being a lot more casual in how the business was run. And that makes it much harder when there is a dispute because you end up with he said, she said. So I think those cases are trickier and you're navigating a lot of emotions as well. So that can be difficult.
What skills and mindset does it really require for you in the litigation and making sense of the complex cases and explaining them to the judge, jury, or arbitrator, or anybody that really is needing to have that communication from you?
So I'm really a lifelong learner, and I think a lot of lawyers are. That's what I do. We're excellent researchers, and we are able to learn things, evaluate them, analyze them, distill them quickly we need to become the expert in our case. But besides that, we also have to then pivot and make sure that we are directing it to the right audience, right? We're going to distill it in a different way for a judge who's been on the bench for, decades than we would for a jury with 12 different individual sets of life experiences that are more varied. And so I'm thinking of it, my first jury trial as a first year associate, and it was a bus transmission case. It was a contract dispute about bus transmissions. But over the course of the year, I became the expert in bus transmissions, and I worked with our expert. And that is really what we do. Even though we have an expert who's coming in who is going to testify at trial, the lawyers have to become the experts. And that's so that we can actually engage with this material, so that we can apply the law and know the facts really, really well. And juries notice that, especially in jury trials, right? Like, that's incredibly important. In that one specifically, I recall that we got the chance, it was in Clark County, Washington, that a couple of the jury stayed back afterwards after we had gotten a great result for our client. And they told us that they really appreciated how engaged we were with the mechanical aspect, and particularly that I had been the one who was engaged with this. In a courtroom of exclusively male attorneys, all the attorneys were men. The jury noticed that I had been the one who was engaging with our expert, who was the expert on our side for bus transmissions. I mean, it's silly, but that's what we do.
And a lot of the disputes that you're in really never make it to trial. You've mentioned that you also mediate cases, and when mediation makes sense. How do you or the clients decide when to push for trial versus settle, and what factors go into that decision?
Almost every case, at least once, goes through a formal mediation process. Every case has some kind of negotiation process, but really, I make sure that my clients understand their risks, the liabilities, the strength of their case, and we go from there. I think a big piece of it too is the emotional aspect of it. Litigation is really hard emotionally. It takes a lot out of someone. Litigation also takes a long time. So I also make sure that beyond just looking at the facts, what evidence we have, how much it'll cost to actually go to litigation, my clients are considering, okay, and I'm going to be in litigation for potentially the next year and a half. And then at the end of that, my prize is sitting through a 2-week jury trial where I have to look at the person, the company, my opponent, who I may not have great feelings towards. That's especially hard when there is a more personal element to a case.
Yeah, I can imagine that being incredibly stressful and demanding. So, business owners, listen up because this is important. I want to hear and understand, what are the mistakes that business owners enter in, that they make before entering into litigation?
So, again, highly emotional. I think you have to make sure that you make an attempt to divorce your first response, your knee-jerk reaction, from what you actually do, right?
Hmm.
But there's also an element of what can you live with, and what do you need to do to be able to sleep at night? So balancing that and really understanding that. In terms of mistakes, when you actually enter litigation or when a conflict arises, sometimes I see that, you know, maybe you have a general counsel who doesn't engage with litigation super often. A lot of my job is evaluating a claim before it's filed and negotiating and figuring out whether there can be some kind of resolution before it ever gets filed, before there's ever a real suit. So I think there's a huge benefit to engaging an attorney earlier rather than later. And maybe that actually saves you money in the long run if you can find a
Hmm.
resolution.
Yeah. So pause, slow your roll. Okay. Take a breath, and maybe get, if you can, a good night's sleep, and then call you guys basically, and or somebody that is in your arena to be able to walk the process through before Mistakes are made and cannot be undone. The outcome that underlines how unpredictable litigation can be. So, what are some lessons that, business leaders can take from those cases?
Well, first, I think there isn't only one right approach. It's very difficult, especially for younger lawyers, to understand that there's not just one right answer necessarily. You can't get an A plus in litigation in the same way that you can predict what your law school classes needed from you. My job really is to evaluate what my clients' goals are, right? Spend the time to work with them. How often have you realized that you may not know exactly what you want? You just know what you don't want. I spend a lot of time making sure that I understand what my client actually needs out of this interaction, this dispute, this litigation, and then going from there, giving them their options, evaluating how we can get there, and making recommendations. And the question is not necessarily, is this the exact right way to do it? But is my client able to reach their goals? Am I giving them their best fighting chance to get there?
I want to take a step back and ask for companies and entrepreneurs, what proactive steps can they take in their business agreements, operations to reduce the chance of ending up in complex litigation down the road?
Now, as much as people want to spend time with me, I know that they probably want to avoid calling me the best they can. So there's a couple of things that I think are really important. One of them is just to make sure that your agreements are actually written down and your amendments, changes to that agreement, that contract are also written down. As good as things are in a business relationship right now, you want to set yourself up for success later on down the road. Even if you're doing business with a friend or a family member, I think that there's a lot of respect that goes into making sure that things are transparent enough and they're actually written down so that you don't end up in a place where you can at least have the same universe of facts, because that's where we get to cases that are very difficult to litigate or very difficult to resolve before you get to trial, where there's different universes of facts. Everyone remembers things very differently. So write things down, please. Another big one is when you're signing contracts, understand what your indemnity clauses actually say. People don't always understand what indemnity means, but by the time you have to figure it out, it gets really expensive because it's usually because you're now on the hook for indemnifying someone. So I'll just give an example, but I recently got married and I had to sign a lot of contracts with lots of different vendors. Almost every contract that I got had an indemnity provision in it, and some of them were crazy. Like they sounded okay. They were
So,
written,
because
yeah,
I want to hear the story, but if you can, just tell us, what does that mean? Indemnity. That's a word probably not everybody's running across every day.
yeah, absolutely. So indemnity is really if I make a mistake, if I accidentally serve, Aunt Beth shrimp and she is allergic to shrimp,
Hmm.
you will indemnify me. You will pay for my litigation expenses and you will, sometimes it's indemnify and defend. So in that case, it would be if it's indemnify and defend, you would defend them through litigation and pay whatever they end up having to pay out. If it's just indemnify, then, they would defend themselves, but at the end of that litigation, you'd be on the hook for whatever it is that they're liable for. So it can be really expensive.
Yeah, there's a huge, like huge. uh,
It's real life.
yeah. So you were saying,
Um,
I didn't.
so a lot of these indemnity provisions are pretty crazy once you actually work through what they mean. You read it, you don't fully digest it, and then you think through, hold on a second. I think based on this language, if my caterer intentionally or recklessly does anything to any of my guests, I am on the hook for defending them. And that's very different than, you know, they negligently spilled some water and someone slipped. That's very different than, well, Now I'm on the hook if they intentionally do something too. If someone is injured because of something one of the waiters does. So I ended up having to negotiate a lot of these indemnity provisions. And a lot of the businesses were incredibly open to doing that because they also didn't fully understand their indemnity clauses
Mhm.
until we talked through, okay, if we take this to its logical conclusion, this is what it looks like. And I'm worried about that. The tiny, tiny percentage chance that this could happen, that's what worries me.
Understood. So, in the litigation process, what are some things that tend to surprise business owners and individuals?
Well, the length of time that these things take definitely is one of the top surprises. And litigation can take years depending on the court that you're in, how long courts take to schedule things, how contentious something is, how long discovery takes. I'm thinking, in Oregon, it's probably going to be the court is going to be scheduled farther out in Portland than it would and in Multnomah County than it would, say, in Josephine County in Southern Oregon. It's just going to be a different scale of cases. So the time, and then tied to the time is always the money. I always make sure to walk through with my clients what that actually looks like and whether that's something that they're willing to take on because it is really an investment to take something through litigation. It takes a lot of work to do that. It's not something that can go on autopilot while you go about your day to day. There will be things that you need to be involved in. So that 2 years isn't just waiting to be heard. It's not just waiting for your day in court, but it's actually spending the money and working that case up. What that looks like is different for every case, but a lot of the times it means hiring experts, going through your own documents, going far back, interviewing witnesses, and doing a lot of investigation.
Wow. Your firm, Markowitz Herbold, is ranked among the top boutique litigation firms in Oregon, known for handling high stakes disputes and achieving multi-million dollar verdicts or favorable resolutions. Why might a business owner choose a boutique litigation firm over a big name, not naming names, national firm?
Well, the work that we do is top tier. It is on par with any big national firm. And we have some of the best trial attorneys on the West Coast here at Markowitz Herbold. So that is a huge plus. But we're also able to be more efficient and our bills reflect that. So while you get the same tier, same level really of work, the end result, it's probably half the cost that it would be with a big national firm. The other benefit is we're trial lawyers. That's what we do. That's our specialty. So from the moment that we are brought on, we're really forecasting and looking forward to that trial and looking at what evidence we really need for that trial. That lets us be more efficient along the way because we're not looking for everything. We're actually thinking about that trial. What does that look like to take that case? We have that experience to compare it to. There's a lot fewer cases that are actually going to trial. So a lot of attorneys just don't have the comparison or the trial experience that our attorneys do. I think that puts us at a great advantage to be able to work a case up efficiently.
Yeah. For small to mid-sized businesses, at what point should they consider bringing in litigation counsel or, building a relationship even before a dispute arises?
It can be really helpful to bring in litigation counsel if there is some kind of a dispute, because, like I said, we can be a great resource in negotiating a settlement before things ever get to the point of filing suit or filing an arbitration demand. If there is a conflict, it's always helpful to get an outside perspective from an attorney, from a litigation attorney. What are your odds? What does your case actually look like? What do they need to make that evaluation if they can't tell you? Right? I think that can give a lot of business owners solace and comfort because I find that a lot of business owners are very independent. They've had to be, and they might have a do it yourself attitude, but this is probably a situation that they just don't have a comparison for. Having a third party who's an expert in this might make it more efficient and allow them to actually reach a resolution. They also don't have the same skin in the game in terms of the emotions of whatever the conflict is.
Yeah, kind of being able to give a play by play for them and the big picture of what everything potentially looks like so they can make a great decision for themselves at any point along the way of how they want to proceed forward. It does make a lot of sense. In the vantage point that you have, what are trends that you're seeing in commercial litigation? And I'm curious about just Portland in general, the Northwest region, or nationwide.
Fewer and fewer cases go to trial because it's getting more and more expensive to take cases to trial. This also has to do with the likelihood of big verdicts. Juries are awarding larger amounts of money. And this is a trend since 2020, not just in Portland, although it's definitely present here. It's present across the US from attorneys and jury consultants that I've talked to. So business owners are getting more nervous to take things to trial because there is a greater scope of what could actually happen. And that makes sense. Not everyone can or should take on that risk of going to trial and potentially getting a huge verdict against them. Now, there are also some interesting trends with juries and kind of identity politics and the social science of presenting to a jury, which I think is really interesting. So, for example, I believe it's called identity threat, but there are more instances essentially of jurors being alienated by things that seem to threaten a core identity of theirs. And that wasn't so prevalent before the last couple of years. So that's on the rise as well.
All right. Well, then let's take a look at your involvement with mentorship in civil legal community building. And curious about your advice for newer lawyers who aspire to litigate and business owners about building a legal savvy organization.
Well, I think for younger lawyers, one of the most important pieces is to get involved with the legal community, get involved and get to know other lawyers and get that mentorship. It's really a community or a profession that relies on mentorship. Law school doesn't teach you, it teaches you how to think like a lawyer. But a lot of the skills that you need to be a lawyer, you really learn from your mentors. Sometimes I look back on a piece of writing or how I approach an oral argument and I think, oh, wow, that is a huge piece of a past attorney that I worked with. That is exactly how they would have done it. And that's why I did it that way. And that happens to a lot of lawyers. Building those relationships and finding what lawyers you want to pull advice and knowledge and how they do things. Like, who is it that you want to learn from? Get close to them, ask them. They probably would love to share that information with you and bring you into the fold. Lawyers are notoriously, I think, bad at building networks sometimes because our job is so individualistic. So much of our time is spent writing or being adversarial with someone. But the cornerstone of what we do depends on our networks. So it's kind of a catch-22. Now, I think for businesses, something that businesses can do to be legally savvy is to have relationships with lawyers early on. Doesn't mean that you want to be involved with litigation, right? But having an attorney who can help you, for instance, draft your employee handbook and make sure that it complies with all your state regulations, state and federal regulations, that's huge. And being able to have that written down and point to that if anything comes up might save you the headache of having to enter into litigation in the first place. So I think that's really important. Lawyers and business owners usually run in the same circles too, and it can be really, really fruitful and useful to have lawyers in your circle, even litigation attorneys, so that when you're not in conflict yet, or maybe the early stages of conflict, you know who to call or who to call for a recommendation for who to call.
Yeah.
So that I think can be really helpful. It's all about the relationships.
All right, red flags and clauses or business practices you wish more entrepreneurs recognized early, things that often would lead to or could lead to litigation down the road.
There are some things where I think if people trusted their gut early on, it might save them a lot of heartache. So I'm thinking of if you're working with someone and they seem shady, or they seem like they're on a different page than you, or they're making decisions without consulting you or anything like that, and it gives you sort of a gut feel, but you're able to explain it away, I think that there is huge value in just listening to your gut and thinking, okay, this might be indicative of what our relationship is going to look like moving forward. Do I want to do that? Is the benefit so high that that risk is okay? And at least acknowledging that you are making that trade off. But I think sometimes that can be difficult. Now, another thing that is also not a red flag necessarily, but I see business owners fail to put things into writing because they put the business relationship above making the record. They don't want to look like they're making a record. And that totally makes sense. They're trying to build a strong relationship where there's trust. And they don't want to say, well, I don't trust you, and that's why I'm writing this down. But I think that there's a really delicate way that you can build the relationship, but you can also make sure that things are in writing. You don't have to be weird about it. Just, you don't have to use legalese or make it really formal. You can just send the email. There's a way to keep track and make sure that at least the basics are written down so that everyone is on the same page.
You've actually answered a couple of my other questions in that. So I'm going to just roll with it. So if you were to say for business owners and entrepreneurs and partners, just 3 to 5 practical steps that they can take right now to minimize the legal risk and avoid ending up in the complex litigation.
Yeah, I think absolutely write things down. And in your business relationships, making sure that you're on the same page with whoever it is that you're working with. I think it's also really helpful if your employees are on the same page as you. Building trust is huge, and it doesn't have to be contradictory to having things documented. I actually think that people find a lot of comfort and trust in people who have things written down. When people work at companies that have things written down and they can depend on how something will be dealt with, that is a huge source of trust. I find that employees will trust the higher ups more in an organization like that than one where everything's sort of nebulous, right?
Right.
So that is obviously a huge benefit for business owners. I think we've gone through a lot of
Yeah.
them, just making sure that your policies comply with the law,
Uh-huh.
update them every once in a while, make sure that you are actually keeping track of that and keeping in contact with whoever it is that helped you draft it in the first place.
I know I promised you a lightning round. Are you okay with us
Yeah,
continuing?
yeah.
Okay, great.
Collaborative.
Biggest myth business owners have about lawsuits.
That they're always going to be disastrous. It's so rare that they're really going to be the end of your business. There's almost always some kind of solution that we can find. We just have to think about it. We have to work through it.
One clause you think every business should include in contracts.
Oh, that's a good one. What happens? Who gets to end the contract and how? And who do they tell and how?
That's great. Final thought. Given the unpredictability of litigation, what mindset should business leaders cultivate to both protect and scale their ventures intelligently?
It's really all about balancing risk. So I know that business owners, at least the ones that I work with, they always have a stronger stomach for risk than lawyers do. And that's by design. But go into it thinking about what your risk is and what you can actually take on. Listen to your lawyers, right? But know that litigation is not the end of the world. Try to avoid it, but some of it is going to be unavoidable. And that's okay because big businesses, successful businesses, a lot of them will have to deal with litigation. It's sort of just a fact of life at this point. So avoid it, manage your risk, and know that it might come anyway. And that's okay.
Josi, thank you for joining us today and sharing such an insightful look into the world of complex commercial litigation. Before we go and wrap up here, is there anything that you're top of mind thinking is crucial or important to leave the listeners today?
I think what I want to make sure business owners know is just that it's not the end of the road. If there is a suit or there's a conflict, reach out to us. We'll help you out. We'll figure it out, and we can find a solution.
What really stands out is your ability to bridge the gap between the high stakes courtroom strategy and the practical business wisdom. And I think that really reminds us that most legal battles start long before anyone steps into a courtroom. For our listeners, if today's conversation resonated with you, or if you're navigating a partnership issue, contract dispute, or business conflict that needs serious attention, you can learn more about Josi and her colleagues at Markowitz Herbold and visiting markowitzherbold.com. They're one of the premier litigation boutiques in the Pacific Northwest and known for helping clients solve problems before and when necessary during trial. Thank you for tuning in to Sterling Insights. If you've enjoyed the episode, please follow, rate, and share the show. That helps us continue to bring you candid conversations with professionals like Josi, who are redefining excellence in finance, law, and leadership. I'm Seth Krussman, and this has been Sterling Insights. And until next time, stay sharp, stay informed, and keep building a future you can stand on. We'll see you soon.
Thank you for listening to another episode of Sterling Insights. Stand out and supercharge your assets, where we provide the info you need from successful leading financial advisors, lawyers, and CPAs. Your hosts, Roger and Catherine Silk, invite you to learn more about Sterling Foundation Management by visiting sterlingfoundations.com.